Hi, this is Dan Chambers, the founder of Chambers Law Firm. This is the final part of this little sub-series I've done on the new SB 1437 law. As I described in the other videos, this law radically alters California's law concerning murder, first-degree murder theories, and specifically felony murder. This last part, I'm going to describe for you how Chambers Law Firm will evaluate your case or your loved one's case in terms of whether or not they could potentially benefit from this new law. Even though we're not at January 1st yet, I'm getting all kinds of phone calls from family members who have individuals that are incarcerated in prison for murder that want to know if their loved one qualifies under this new law. This is how we evaluate those cases. Step one is we obtain as much information as we can from that family member about where the case was conducted, where the trial happened, case numbers, and things of that nature. After that, step two is we start gathering the documents and information. Typically what I do is I look for that person's court of appeal decision, because most murder convictions are actually appealed to a higher court. That higher court then issues a written ruling. I try to find that, any news articles about the murder, any pieces of trial transcript that I can find. After step two is completed, I then start looking at step three. Do they qualify under the new statute? And that gets real complicated. The major reason it's complicated is that it's not always clear what the prosecutor's theory of first-degree murder was for that person. And until I know that, it's hard for me to make that determination. So what I do at that point is I try to drill down even further to find out what jury instructions were given to the jury. What was the ultimate sentence handed out by the court? And whether or not in that court of appeal opinion, for example, there's a description of what that defendant's conduct was. Once I've looked at all of that information, I'm usually in a position to give one of three recommendations. Number one, the person simply doesn't qualify. The most simple example of that is if I find out that that defendant was the actual shooter or the actual killer involved in the murder, they do not qualify. The second possibility is that the person is an excellent candidate for SB 1437. An example of that would be the classic getaway driver who thinks that a robbery is going to happen at the liquor store, and as he drives away finds out that somebody inside that liquor store was killed during the robbery. That's almost the poster child for this new law and would be an excellent candidate for resentencing. The third category is I can't tell yet. And what that means is that based on all the information I could find, I need more data. I need the actual trial transcripts. I need the actual jury instructions, or I may even need to talk to the client himself to find out what happened. So based on that information, that's how we go about determining whether or not that person is a candidate for relief. If you have any questions about it, if you or a loved one think that you might be eligible, contact Chambers Law Firm today. We are up to date, we are out in front of this statute, and we'll be able to tell you what your prospects are. Thank you very much for watching.